The petition is in. SCOTUS finally sees our challenge to California's magazine bans, and the questions are these, and there is two. One, whether a ban on possession of exceedingly common ammunition feeding devices violates the Second Amendment, and two, whether a law dispossessing citizens without compensation of property that they lawfully acquired and long possessed without incident violates the taking clause. This is Duncan v. Bonta. Let's talk about it. Hey everybody, welcome back to the channel today, and that is right, that day is finally here. We have turned the corner and we can now once again see the finish line and the tape for that finish line in the Duncan v. Bonta case. To walk us through that, we have brought back on CRPA's volunteer president. That of course is Chuck Michel. Chuck, thanks for being on with us today.
Always a pleasure, guys. Thanks for having me.
Absolutely. And guys, once again, be sure to like, share, and subscribe to these videos. It really helps and it goes a long way. We want to get the word out about this. We want to see a victory here that can potentially change the scope of the way that these courts are allowed to apply Bruen. Obviously, we think that they're not doing that correctly, so more cases that we can get to SCOTUS where they can more clearly define what they meant in the Bruen decision, the better. It's a great way for you to directly contribute to campaigns just like this. Getting the Duncan case to the Supreme Court, ultimately being victorious, is the obvious goal there. But please be sure to like, share, and subscribe. It really helps the channel. It really helps the overall effort, and thank you for doing so. So Chuck, before we jump into the petition, which was put in today, can you go ahead and you know, a lot of people I'm sure have been following along with us on this, but for those who haven't and are coming in the fourth quarter here, can you just go ahead and talk about the path that Bruen or that Duncan has taken to get to this point? Now we're going to go over some of the claims and the arguments in a little bit, but just the pathing specifically, can you go over what it's taken to get this petition to SCOTUS for the second time?
Yeah, well, it's been a long, strange trip through the court systems at every level. We started in San Diego. I'm going to do this in a nutshell because this case has been going on for 10 years.
Yeah.
So we started in San Diego Federal District Court, the trial court, with Judge Benitez. We challenged the law banning possession of magazines that can hold over 10 rounds. We won on Second Amendment grounds in front of Judge Benitez. This was before Bruen. We won based on Heller, which was the right ruling. That went up to the Ninth Circuit to a 3-judge panel. We won again in front of a 3-judge panel because the state appealed. Remember that first time around, the injunction was not stayed by the Ninth Circuit, so we had Freedom Week, where about 1 million of these 10-plus round magazines were sold in the state of California. So there was quite a bit of pent-up demand. We won in front of the 3-judge panel. Then the state asked the en banc panel, which is an 11-judge panel in the Ninth Circuit that can review a 3-judge panel's decision, to review the decision, and we lost 7-4. And that was at a time when there were more progressive liberal judges on the court by a factor of about 2-1 than conservatives. We took that to the United States Supreme Court. The Supreme Court held on to that petition for certiorari to grant review until after the Bruen case came down. When the Bruen case came down, they granted our request to review the Duncan case. They vacated the en banc decision, in other words, wiped it out. And then they sent the Duncan panel, without deciding it, they sent it back down to the Ninth Circuit saying, reconsider what you just held in light of what we just said in Bruen. The Ninth Circuit Court of Appeals sent it back down to the district court again in front of Judge Benitez again, and we won again. And that was after a long trial where a lot of evidence and expert declarations and things were submitted. Then it went back up to the en banc panel. I think it incorrectly skipped a 3-judge panel, went right to the en banc panel that had heard it the first time around, and we lost again, 7-4 in front of the en banc panel. And there's all kinds of criticisms on how that en banc panel was put together, and those are laid out in the brief. Folks, if you to get the details on this and see how much work we've had to do to get this case to where it is, It's all in the cert petition that was filed today, asking the Supreme Court to take this case. And so that's where we're at. Because of the second time around through the en banc panel, we've now asked the Supreme Court to take the case again. And this case now checks all the boxes on what the Supreme Court looks for. So I got to say, this is probably the most likely case for the Supreme Court to review the Second Amendment methodology that Bruen mandated, that's going to come out this session in the Supreme Court.
All of that to say, it's definitely a longer road than most lawsuits take. It has been a decade-long battle, so let's go ahead and talk about that. And remember this, guys. This is a petition. This is an appeal to the Supreme Court. Just like we recently saw and discussed with the Rhodey case, these appeals end up looking a little bit different because the complaints themselves and the argumentation themselves are sort of implied within the appeal. But Jacob, if you could pull it up, this is from the petition for certiorari for the United States, and I wanted to pick your brain on this, Chuck, in just a moment here. It reads like this. Things only get worse from there. Although its threshold textual holding logically meant that the case was over, the Ninth Circuit proceeded to muse about historical tradition, and what it had to say was eerily reminiscent of the interest-balancing approach Bruen interred. The court justified California's ban by declaring that the millions of Americans who possess 10-plus round magazines do not really need them, and it doubled down on its hostility to Bruen's framework, making the claim that even if such magazines are arms, the very same historical regulations that Heller held imposed no burden on the right at all suffice to justify California's ban. That all smacks of a result in search of a reason, and it vividly illustrates why the court must provide more guidance on which arms the Second Amendment protects. Indeed, the Ninth Circuit refused to even engage with the historical tradition that this court has recognized protecting arms in common use, deriding the common use test as too simplistic, undefined, and speculative, and a facile invitation to rely on ownership statistics theory of the Second Amendment. As that decision makes all too clear, lower courts set on blessing arms bans will continue contorting what little guidance they are willing to concede this court has offered, and the only way to make that stop is to squarely decide the issue once and for all. And Chuck, the reason why I wanted to bring this up, I mean, I first of all, I thought this was really powerful because along with this discussion on ending the magazine ban here in California has been the discussion of the Supreme Court setting straight these lower courts that continue to misapply the Bruen methodology. Is that basically the aim here with saying not just, hey, these guys are misusing the Bruen decision, but these are the specific places that they're doing it?
Yeah, this is not just about magazines. And a suppressor case is not just about suppressors. A semi-auto ban challenge is not just about semi-AR-15s. I mean, the methodology of that the Supreme Court set out in the Bruen case has been twisted by lower courts who don't want to strike down unconstitutional gun bans. And so their logic is so contorted and distorted that they can apply the wrong tests in any case and justify upholding any law. Conversely, if we get the Supreme Court to clarify emphatically how they have to apply the test, the two-step process methodology in Bruen. First, is it an arm covered by the keep and bear arms language of the Second Amendment? Magazines clearly are, and not only that, conduct relating to magazines, ammunition, or relating to firearms. Going to the range, hunting, self-defense, all that stuff is part of the right to keep and bear arms. And then the second test, actually, that's not even a test, that's just a question. Almost everything is an arm or covered by the right to keep and bear arms. And the second inquiry is the modern day law consistent with the historical tradition of gun control laws? And the courts have gone out of their way to stretch that analogy so that a Bowie knife law justifies a AR-15 ban. That's another thing that the Supreme Court really needs to smack the lower courts down and tell them emphatically and clearly and unequivocally that they need to follow what the Supreme Court said. When that happens, we won't just win Duncan, the magazine case. We will be able to strike down a lot of unconstitutional gun control bans, gun control laws and gun bans. and take back the freedoms that California politicians and bureaucrats have been stealing from us for decades.
Yeah, and I do want to get into ripeness and timelines in just a second, but let's talk about the potential application in a victory for a second. We saw the Bruen decision. Obviously, that sets a precedent. It sets a process by which the courts look at these Second Amendment lawsuits. You even get a little bit of that from the Rahimi decision, but neither of those cases saw any direct impact. Insofar as nothing was being challenged from the state of California. We didn't really talk about what happened in New York when SCOTUS gave their decision on the Bruen decision and what that actually did in New York for the concealed carry laws there. Applying that thought to this case, do we see an immediate impact in California with magazines if SCOTUS were to take this case and then give us an opinion in our favor?
Well, if we win,
yeah,
these magazines will be available for sale, at your local retailer or from your neighbor or wherever. I mean, the sale will be unrestricted, sale and transfer. So you'll be able to buy them online. Now, California will probably try and do something else because they don't give up. They'll who knows what trick they will have up their sleeve with the coaching of the lawyers from Bloomberg's group, because those lawyers will want to parachute in and try and still make it as hard. That's their game. They want to make it as hard and as expensive to own a gun and use a gun as they possibly can, so they discourage as many people as possible from getting involved in the shooting sports or buying a gun for self-defense. But that said, if we strike down the law, you'll be able to acquire these magazines and keep them and use them.
Right, and there's no other court that they can appeal to put a stay on an injunction or anything like that. Supreme Court is at the top of that hierarchy, so definitely something to look forward to, and this is why we're paying attention to this and pushing for it so carefully and so adamantly. You already talked about ripeness a little bit. I wanted to bring another element into the thought process on that. You already kind of stated that Duncan checks off some boxes. We saw Ocean State Tactical, which was up on interlocutory appeal, get remanded back down. Duncan isn't exactly that way. It's got judgment from the lower court. But
correct. It's a final judgment after 2 trials with tons of evidence in the record. So it's a fully developed, fully baked cake.
Yeah, and alongside that, you also have the Snopes case, which you saw a dissent from Justice Thomas saying, "Hey, there's no reason why we shouldn't be deciding this now." But essentially, you had the majority opinion given from Kavanaugh saying this is something that needs to be addressed, just not necessarily right now. You're saying that Duncan overall in the landscape looks like it's the one that's kind of first in line for them to take. Do we expect anything out of the ordinary like we saw with Snopes and Ocean State Tactical being held onto for a long time, or do you think there's enough incentive for SCOTUS to take this and take it quickly?
That's a difficult question to ask because it doesn't really tie into the merits of the case, how long they sit on it in the Supreme Court, because they have all these Trump appeals and requests in front of them. It's more a calendaring priority than a legal strategy on which case the Supreme Court considers and takes or doesn't take first. It's basically how busy are they? And they're very busy with Trump stuff right now. So they might postpone the conference on whether or not when they're going to vote on whether or not to take Duncan. They might postpone it a few times to give the law clerks a chance to really study the record, for one thing, all the things that have been filed over, 8-9 years, and then just get around to briefing all the other judges on it. It's really a matter of prioritizing the different cases that are coming in based on what they think is more important. And a lot of these Trump cases are going to be something they want to pay attention to right away.
Well, and I'm sure if you asked, Clarence Thomas, he would want to take it yesterday. But there is definitely more to contend with there. I guess my final question to you is final thoughts. When SCOTUS does decide to take it, what are the general timelines of the Supreme Court of the United States. When would you assume this gets heard? And what are your final thoughts on the appeal itself moving forward?
Well, if they take it, they'll set up a briefing schedule, they'll set up oral argument, and they'll issue a decision. We'll probably get that decision in June, at the end of the current Supreme Court session. When exactly the briefs would be due and when oral argument would be, I can't say, but that's again at the court's calendar. So, I expect we'd have a decision in June.
Well, goodness gracious, if
Final thoughts are, hey, this is a historic time for the Second Amendment. If this case or whatever the next case that comes along, one of them is going to get accepted. And when it is, it's going to change the game. Don't give up hope. We are going to win. Support the CRPA's efforts so that we can keep filing lawsuits and challenging the blue resistance in Sacramento that doesn't like you to have a gun.
That's kind of what I was going to start saying. If ever there was one to pay attention to at this point in time, this is definitely the one. We're going to be following along as we always do. Chuck, I look forward to having you back to talk about potential oral arguments and potential decisions there. But thank you very much for coming on today. I appreciate it.
But read that brief. You'll love it, folks. Read that brief. You'll see some of the work we've done on this case.
Absolutely. And guys, if you like videos like this and you want to see more content, you want to continue and follow along, please be sure to like, share, and subscribe to these videos. That subscription, it gets you notifications when we come out with videos just like this, informing on Supreme Court cases. So please go ahead and do that. It helps the channel out and it helps the movement out as a whole. Thanks again, guys, and we'll see you on the next one.